ಇದೆಯಲ್ಲ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 29 ಇದೆ. ಅವ್ರೇನಾದ್ರು ಬಂದ್ರೆ ಒಂಚೂರು ಆ ಕಡೆಯಿಂದಾನೆ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 29 ನಲ್ಲಿ ಇದ್ದಾರೆ. ಎಂತದು ಇವರು ಮಾಣಿಕ್ ಪ್ರಭು. ಹೌದು, ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ. ಒಂಚೂರು ಇದ್ರೆ ಸೆಂಟ್ರಲ್ ಗೌರ್ಮೆಂಟ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಅಂತ ಸ್ಟ್ಯಾಂಡಿಂಗ್
fresh matters, my lord.
What is the urgency?
Urgency is, my lord, the initiation of action against the petitioner for, my lord, on the ground of my holding, my lord, two posts simultaneously. That's an office of profit. On that ground, my lord, the Lokayukta has initiated action.
Just later next week we'll have.
On Monday or?
We'll see it. Just see the.
This is the matter, my lord, yesterday I argued,
you have
written
submitted.
argument, my lord, I served the copy to the other side.
Give that also, this also, take it.
Fresh matter,
You do one thing,
please.
you will, one file it, you file it in the registry. So that that file also can come in the registry and give one each copy to us. Is it
Please.
possible?
Please.
In the point, file it in registry, one copy each, and give these two copies to us. Okay?
ಕಾಪಿ ಇದೆಯಾ ಸರ್? ಫೈಲ್ ಮಾಡ್ತೀನಿ.
My lord,
Do one thing. Possible, one each of you do the e-filing. Go to Seva Kendra, go to e-filing, they'll e-file it. It will come automatically as an e-file in the record. You give the physical copy to us, that we will take it. Getting the point?
Please.
File it.
Hard
e-file.
copy, I have a hard copy also, I'll file it in the counter.
No, do the e-filing. Not in the front. Go to e-Seva Kendra, just tell him they'll scan it and put it.
Please.
Okay? Do that and give the full copy. Just give it. Take it, ma'am. Leave it in the.
no.
Yes.
My lord, one writ petition challenging
Fresh matter.
order passed by Justice Keshav Narayan committee. I had moved it day before yesterday also. It's not listed, my lord. There is urgency.
Objections, you remove the objections.
My lord, office objections are complied, my lord, and my lord, the BDA is trying to allot the sites and also to release the compensation in favor of the owners. There is extreme urgency, my lord. May I request for 2:30, my lord, today?
Not possible. We have to go through the file. We'll have it on
Tomorrow, my
Monday.
lord?
Monday.
Monday, please, ma'am.
Monday. Just give it on
My lord,
Monday.
fresh matter for Monday, matter pertaining to selection.
What is the urgency? Urgency
Application was rejected by the concerned authority.
for what?
Firemanship, fireman post.
Just one. We'll
And,
just check up that. Is it our roster?
Lord,
Just one. Is not our roster?
My lord, Karnataka land grabbing court proceedings challenged in the writ petition, my lord. Pendency of the proceedings, my lord, the complainant, my lord, has executed the register release date. Matter is almost are settled, my lord. The proceedings, my lord,
Is your petition pending here?
pending here, my lord.
What is the date?
My lord, date is not given, my lord, notice was served. And pendency of the proceedings, he has executed the confirmation to the respondents, my lord.
No, but you have
And
to
matter
inform,
is ended in the compromise, my lord.
you have to inform the other side also.
Yes, my
Whosoever
lord,
is appearing.
I will inform.
Just give it, ma'am, after next week. I will give it. This is our roster, no?
Yes, sir,
Just check-
KLGP.
Just check up that.
Yes, yes, please.
My lords, serial number 27, my lords, list
Please,
one.
Your lordship's kind permission.
Minutes, sir.
One matter tomorrow, please, my lord.
What is it?
Consumer forum matter, for the respondent. So matter is connected with other petition, last few, 2 months back, the matter has been stayed and posted for call after 2 weeks. Matter is not posted before the court, please, my lord. For the respondent number 2 in this matter.
Is there any connected matter also?
Connected, yes, my lord.
When is that matter coming?
That's not as posted, please, my lord. This matter has been posted along with that matter, not posted both the matters. And I'm for the petitioner in the court below.
You are the party in that matter
Please,
also?
no, I'm not a party in that case.
But then how? can we-
Similarly placed matter,
You're right, both the petition need to be decided together.
please, my lord.
So then you have to get that also listed. Who is the
If this is
counsel?
listed tomorrow, that will come along with that matter. I'm second respondent in this matter only, and this was posted along with that matter in the order sheet.
Right, but you have. to-
I'm not a party in that case.
The other council must know now the matter would be coming. That matter,
Yes, my lord.
then do one thing, just get it listed next week.
Yes, please.
Your lordship's kind permission.
Yes,
My lords, there's a memo seeking for withdrawal, my lords. This
which
matter,
matter?
my lord, this is a matter challenging the.
Is it listed today?
No, my lords. I'm moving a memo to withdraw the matter.
Okay, then what is the matter about?
My lords, this is the matter challenging notification of issuance of smart card licenses, my lords.
Is it part of this roster?
Please, my lord, please. It falls under the writ petitions which are not, sorry, my lords. It's a writ petition, my lords. On the previous occasion, it was heard by a division bench.
Our roster? Let me just check up that. matter. Is it part of our roster? See, we'll
Yes,
do
sir.
one thing.
Yes,
We will just check up with the registry. The court officer will check up. You come after lunch. Then just check up only. Don't give any this thing. Just check up.
my lords, if I make one submission, on the last occasion, this, please, very much.
We want to be sure.
Yes, sir.
Okay, come after lunch. Yes,
Lords, if
For
I may make a
adjournments.
mention, my lords.
just one. He wants to mention it. Yes,
Lord, list one, serial number 27, my lords, we appear for the petitioner.
just
Lord.
hold on. We just call the list.
For-
Please, ma'am,
For
please.
adjournments, page number 5, 22. Page number 6, 23 to 27.
My lords,
Serial number 26, my
we
lord.
appear for the petitioner.
Yes.
Serial number 27.
My lord, 27, I appear for the respondent, my lord. I have some, I oppose any adjournment in this matter, my lord. It
But,
is
in this-
court hall moved, my lord.
My lords, arguing counsel has a.
My lord, I had in fact even informed them before moving the memo. So there
What
is
is the
some,
difficulty? What is the difficulty for the council?
Lords, arguing counsel has a part heard matter in another court, my lords, and which is preventing him from appearing before this honorable court. My lords may kindly grant a short date, my lords, and we will appear before the court, my lords.
my lord, it's an award which was passed in the year 2020, my lord. There is no stay also. There
It's
is
all
no
right.
complaints.
He has not moved
Lord-
till date. He has not moved till date for the execution.
No, my lord, I was discharged from service. The industrial tribunal has now said that
You
I
are
should
for the
be given.
respondent.
I'm for the respondent, my lord. I had moved the court.
We will have it on a short date.
Please, my lords.
Request for adjournment is made on behalf of the council for the petitioner. Re-notify on, just give a short date.
25/9, sir.
Serial
Date,
number,
my lord.
serial number 26, my lord.
26 you are mentioning, ma'am.
Yes, yes, my lord.
Hmm.
Senior brother has expired yesterday, my lord.
Who has
Yeah.
expired?
Senior brother, my lord. Senior brother, my lord.
Okay. Adjournment is sought on the ground of personal difficulty of the arguing counsel. Re-notify.
2310,
Much obliged, my lord.
page number 7, 28 to 32.
Serial number 32, my lords, I appear for the respondents. I've informed the appellants, my lords, I request for a short date in the matter.
Who is the other side? You are, who is the,
No.
but
One
have you
Mr.
mentioned the other side?
I've informed him previously, my lords, his request is not to post it on the 10th. Any other date is okay with him.
Because this, it appears we have heard it.
My lords, we've just filed the wakalat on behalf of respondent 1 to 3, and we were in the councils on recording the writ petition. So request
So
from
do one thing, ma'am, just call the council and we take up the matter.
appellant council.
Just call him.
Please.
Okay.
My lord, serial number 33, my lord.
33.
Well, my name has not been shown in the cause list, my lord. And this is NOC brief. I want a 1 week accommodation to get some more instructions.
But today is a fixed date, no? in
Yes,
this?
my lord, but despite of the court order, they have not shown my name in the cause list, my lord.
Have you mentioned the other side?
Yeah. No, my lord, I don't have the number.
You should tell him. We'll just take up, when the matter we take up, we'll consider.
Please.
I appeal for the respondent.
Which matter?
Same, the 33 million.
33 wants an adjournment.
Short accommodation.
At the request of counsel for the petitioner, which is now for an adjournment, which is not opposed, we notify.
My lord, kindly observe, my lord. My SV Desai name may be shown, my lord.
Mr.
Yes, SV Desai, my lord.
The registry, Mr. Abhinay is not appearing now?
No, my lord, it has been withdrawn.
SV
Desai.
Desai's name shall be shown in place of Mr. Abhinay YT as counsel for the petitioners.
Much.
Next.
2410.
Your Lordship,
Serial number,
Lordship, if I may mention, serial number 20, Your Lordship, we had to seek some instruction from the client regarding the revision petition pending before respondent number 1.
Who is the,
The opposite side is the state. I've informed them, Your Lordship.
have you informed them?
Yes, Your Lordship, I've informed them just now, the respondent state. They filed the application for vacating stay.
Let the matter be called. Once we call the matter, the counsel will be there, we'll adjourn it if he has no objection.
Okay.
Call ma'am.
serial number 1, Shri Nishit Kumar Shetty.
The petition for time may be granted to remove the office objection, my lord.
6 weeks are granted to remove the office objections. Two.
2310, serial number 2, Shri Vincent.
You file your objection, Mr.
Yes.
Yes.
It's called for the first time. Do not plan some time, week's time.
Where is the counsel to press the petition?
Shri Vincent.
Just pass over, Miss.
Yes.
Just pass over.
Yes.
Serial number 3, Shri Pradeep Kumar.
Yes, ma'am. Week time.
There is a statement recorded of the alleged detainee, who is the mother of the petitioner. She says she has voluntarily gone away from the house, and I don't think they will have any grievance.
Lord, without informing us this event, I have lodged a complaint, but they have not taken complaint. Because of the election was held on 23, because
But
of.
where is she
politics.
now?
She has.
She's back
given
home.
a statement,
Where is the,
just received the statement.
what does she say?
She's back, she's back.
She's back home.
Yes, yes.
Now she is back on, but
Then what do you want?
maybe dispose of, please.
You want to withdraw this then?
Please, please.
I'm sorry, it is in Kannada, we just received the.
Huh?
It's in Kannada, I'm sorry, we could not translate it.
No, he wants to withdraw it.
Yes, yes.
He seems to be very happy.
Outside.
Because of politics, my lord, ruling government she has taken,
What do you want now? You
now
want,
I will maybe.
Withdraw it.
Please, please.
shall we take this on record?
Yeah, not necessary if she's going to.
Give it back. Learner counsel for the petitioner states that he has instructions to withdraw the petition.
Please,
The petition is dismissed as withdrawn.
please.
Serial number 4. Shri Suresh,
Well, it's 2 weeks time may be granted to comply the office objections. my lord.
8 weeks are granted to remove objections.
Much.
1211. Serial number 5. Shri Srinivas,
My lords, I appear for the appellant in this case and grants a kind week's time, my lord. Pray for a week's time.
3 weeks are granted to remove the these objections.
8 to 10. Serial number 6. Shri Abhishek Chandragaud. 6.
4 weeks are granted to remove the office objections.
28 to 10. Serial number 7. Shri Nagarajappa.
Pray for a week's time, my lord, to comply with the office objection, my lord.
8 weeks are granted to remove objections.
411. Serial number 8. Shri Kumar. Serial number 8.
8 weeks are granted to remove the
Seventh.
pass over, just pass over.
Serial number 8. Pass over. 9. Shri
Appearing
Harish.
for the appellant, my lords, had complied with the office objections, my lord. Subsequently, they have raised new objections, my lord. A week's time may be granted to remove.
4 weeks are granted.
2 weeks is done.
4 weeks
Please. A date may be fixed.
to remove office objections.
2510. Serial number 10. Shri Nataraj Ballard.
I am for the petitioner, my lords. My lords, as per the order dated 23/3/2023, we have served the copies to the respondent and we have filed the memo, my lords. We have complied the orders.
So, what do you say?
As per the order dated 23/3/2023, we have served the copies to the respondent and we have filed the memo before the counter on dated 31/3/2023, my lords. Kindly it may be posted for the hearing, my lords.
Disposition of WP, what is this?
Next one. Okay.
This is also the challenge before the DB, sir, 24,000. Before DB, the challenge 24,000. 24,000 rupees is only a challenge. Advocate fee will be 24,000.
This is what we do there, challenge. Ma'am, what is there here in this matter? Who is the senior?
Nataraj Ballal.
Just call him.
He is out of town, my lords. It may be have it on Monday, my lords.
At the request of counsel for the petitioner, we notify. We give somewhere in September only.
My lords, it's showing that it may be have it for a dismissal. in the e-court. So
Yes.
27/9. Serial number 11, Shri MJ.
Lord, I'm filing the status report.
You are filing it? He is filing the status, but just give a copy to him.
Yes. Lord, as far as DLS is concerned, District Legal Services Authority, we have filed, submitted the report. Once in 3 months is what we are required to submit.
Would you like to look into this?
Please, my lord, please. my lord.
Just because you sought time also.
I'll refer to this and then I'll make my submissions. Because, my lord, as per the orders dated 5/1/2021, certain directions have been issued by this honorable court. Despite this direction, my lord, C report is filed by the police. C report is filed closing the matter.
So we have
But
asked-
were you given that report?
My lord,
Earlier, there was an order of the court, what we have read.
My lord,
Should be given in a seal cover to you for you to.
my lord, the direction was to the I am permitted to take your lordship through the directions issued by this honorable court. Dated 5/1/2021.
That was submitted, that was addressed on the last day.
You do one thing, you file a response to this.
Please, my lord,
Better would be there.
please.
You file it in the register.
We will.
Also a copy
Yes.
e-filing, do the e-filing.
E-file, we'll do that.
And will you do the e-filing?
The response.
I'll try, my lord.
No try, you will file it.
Great.
The learned SPP has filed a status report, same is taken on record. He shall also file additional copy of the status report through e-filing.
Great.
Yes, one minute. See, we want that you should also suggest.
Please, my lord.
Now it was how many years back?
It is 2006 years back, 2018, my lord.
No, the boy went missing.
2018, my lord.
18, what was his age?
His age was 8 years at that time. He was born on 18/9/2010, my lord.
He must be 14 now,
Must be 14.
but he can still be identified.
Please, my lord, he
Can
can
still
be,
be recognized.
certainly, my lord, he can be recognized. A boy of it is actually a case of kidnap, my lord. Therefore, immediately the case was registered for kidnapping only. But subsequently, no action was taken. That is the reason why, my lord, all these things.
Now, we have suspected about 6 persons. Now, we have sought the permission of the court below to conduct polygraph test. That is granted. So that is the stage we are at, my lord.
Polygraph test.
Yes,
You could able to identify any persons.
yes, suspected persons. Now we have identified.
So so now that test need to be carried out.
Yes. And I have.
How long that would take?
Lords,
How long that would take?
would the lordship kindly adjourn it by 2 weeks? We will.
Please.
Would you have any instruction? The officer wants to say something. You want to say something?
He says 2 weeks is not possible.
You file your response to
Please,
this.
my lord.
What action they propose to do it is, in any case, how much time?
My lord, now I've stated in the last but one page about the permission being sought and granted. It would take 3 months, he says, for all these to
Why
complete.
so much time?
Narco and polygraph would take so long, he said. Well, kindly adjourn it after a month, we will see the progress, my lord. And
But there should be some progress. It's
Yes.
not like that you're just coming and taking further time.
no, in the status we have stated.
That need to be, they have to work.
Follow it up. We'll follow.
Just imagine, you're right. You can just say this, say we have said, status quo.
Yes.
For this status report. Okay.
Yes.
The learned counsel for the petitioner submits, he shall file a response to same within 4 weeks. Just re-notify after 4 weeks. Grateful.
1510. Till number 12, Shri Mukana.
I'm the petitioner in this case. In respect of respondent number 2 and 4, kindly direct the government advocate to take notice on behalf of R2 and R4, my lord.
Just say notice to R
R2,
2, 4 and 6 is still
6, my
incomplete.
lord, the party person, ಬೇರೆ person, Swami.
Who is
I will-
party's person?
R6, my lord, I will take fresh steps.
No, why not 2 and 4?
2 and 4, my lord, the, on behalf of government advocate is represent, my lord,
What, which are
central
these?
government advocate.
Postmaster General.
Because he's already filed the statement of objection. Additional.
So we
central-
just see, let's see if they are part of the government, then we can ask them.
My lord, the post
Who is the Postmaster General?
general.
And the 6 is the,
6 is the Vijay Kumar, my lord.
uh,
6, respondent number 6
is
is
the person
person, my lord.
who appears for the other respondents.
That's why additional central government council, man. The statement of objection and additional repress statement is filed by.
Just say this, cut that, man. 2, 4, 6 are still not served. Liberty is granted to the counsel for the petitioner to serve the copy of the petition on the counsel appearing for respondent number 1, 3. 1, 3 and 5. Okay,
Much.
full stop. The notice, separate notice shall be issued to respondent number 6,
Much.
returnable on.
Much.
711. Serial number 13, Shri Rajshekar.
So my apologies, my lords. I filed the affidavit, my lords, but by oversight, my office has filed only one set, my lords. Second set is ready, my lords. I may be permitted to file it.
Okay, Mr. Rajshekar says the second set of the affidavit shall be filed. You are filing it today?
Filed, my lords.
Has been filed in the court today. Full stop. Now what?
My lords may kindly recollect, my lords. This is with regard to, my lords, the Official Secrets Act, my lords, near Mysore. And by violating the provisions of Official Secrets Act, my lords, the lands are acquired. And my lords, the properties are, my lords.
Have you filed your response, Mr. Arbaki?
No, my lord. On the last occasion, I pointed out, my lord, that there is delay and on the ground of delay, my lord, Honorable Lokayuktha has refused to, my lord, take.
That interpretation of section 8.
Yes, my lords. My lords directed me to file better affidavit. And I have filed the affidavit, my lords, now.
Because we.
Now tell us one thing, Mr. Rajshekar, what is otherwise the interpretation to section 8?
My lords, my respectful submission is, my lords, section 8.
Do one thing, can you do one thing?
Yes, ma'am.
Can you file your brief note of submissions and the judgments?
Yes.
Can you on this? This is a pure issue, question of
Question
law.
of law, my lords, section 8D, my lords.
Maybe need to be seen in the facts of that case.
Yes.
It's a mixed question.
Yes, please. That is what my lords on the last date of hearing expressed and directed me to file better affidavit for the delay.
We will still see those facts are rather. If the facts are admitted, then what is the effect thereof? We will
Yes.
see that.
Now, interestingly, my
also
lord,
file.
interestingly,
Not
my
on the
lords,
question.
the authorities themselves have submitted a report saying that, my lords, yes, there are encroachments, there is violation of Official Secrets Act. And my lords, the action
Why?
needs to be taken.
How will Official Secrets Act come in?
My lords, this Shivana Samudra, my lords, the electric power plant, my lords, in and around that area. My lords, approximately about 4,000 acres are, my lords, notified as, my lords, under the provisions of Official Secrets Act.
You will see, just file. You just say this, and the counsel for the parties are also directed to file their written submissions along with the judgment they want to rely upon. For hearing, just say that for hearing.
Please.
2210.
Great.
For the petition.
14,
Grateful, my lords.
serial number
I
14.
appear for the appellant, my lord. This matter about annexure D has happened, my lord. Annexure C and C, there were two annexures C and C1 filed. In the writ petition, it was written as C and D. That's the office of, my lord. D is the application made by me for allotment of such subsequently, my lords. My submission is the office of may kindly be overruled, my lords. Your lordship, may kindly page 47.
But what is the case on merit?
What is the case on merits? Please, my lord. Here, I was informed today, my lords, regarding reallotment, cancellation of sites, the division bench has taken some view. Division bench has taken view regarding such cancellation of sites, my lords. I could not lay hand on my judgment, but while coming, I could find it on the net. Could be taken day after tomorrow, I'll place the judgment also.
At the request of
No,
counsel
my
for the
decision-
appellant, re-notify. Now, what was the objection you said?
I'll answer that question. The petitioner, the appellant belongs to a scheduled caste, my lords.
No, on annexure D. Annexure D, what is the objection? What is your submission?
Office objection regarding.
Office of Petition, my lord, what had happened, my lord, annexure C. Yeah, I'll come, my lord, annexure C was in the two, this, my lord, 1 and 2, like this, my lord. And annexure D was the next annexure. While typing in the writ petition, my lord, this was mentioned as annexure D inadvertently. So that is because of confusion, my lord. I tried to explain to the office, my lord, because the annexure D is the subsequent application made by me.
But you have separately filed annexure D.
Is it separately filed?
No. It was there in the previous writ petition. It was in the writ petition, my lords.
In view of the submission made by the counsel for the petitioner in respect of office objection at annexure AD, in respect of annexure D, the same is overruled. Full stop. He seeks time to file his written submissions. Re-notify. And who appears for the right to the respondents? No one, na?
Respondents. Who appears?
Index.
Who is appearing for us?
Mr. Kiran was appearing, my lord.
No, we say nothing.
Divi Kiran.
You have to satisfy us insofar as the notice to be issued. That needs to be done.
Only to BDA, my lords.
Why should do BDA? BDA? We have to agree with you that it requires consideration.
Who appeared? Merits, madam.
Once you have paid money, you withdrawn it.
I
where is
got
the
some
question?
hearing problem, my lord. She's asking.
Once you have withdrawn money, just tell him, once the appellant has withdrawn the money, where is the question of reallotment? You can tell him.
Yes, I got it, my lord. Once money was withdrawn, your lordship put me the same question last time. At page 49, your lordship can kindly turn to my lords. Page 49 is the translation. What 50 is the translation, my lord. I requested, it's true, I requested for refund of the amount because I had to pay my daughter's education fees, my lord. But there is a proviso, my lord, in Rule 10.
What does it say?
I'll just read it. Rule for 13, my lords, proviso provided where the allottee is a person belonging to scheduled caste, scheduled tribes and backward tribes or family of defense personnel killed. This is further, my lord, the balance of the value of site to be required under sub-rule shall be paid by him without interest within a period of 3 years of equal installments from the date of receipt of the notice of allotment. No, my lord, this factor was not known to the appellant, my lord. He gave a letter to the secretary and the secretary also said we'll refund the amount. If this provision was.
But after how many years you sought the payment? Was it before, beyond 3 years?
The poor fellow went on representing my lords. Thereafter, at the same time, he made 9 allotments. He sought for allotment or he made 9 applications. His application is still not considered. My submission, lord, if.
But then if you were not having the idea about this provision.
I had no idea.
You did not put it to the learned single judge also. You did not.
No, the issue is this one. I did make, my lord. I did make.
Did you
Yes,
tell
ma'am.
this? Where is the position?
I'll just show it. I'll come to that.
Just show us that.
At page 14, my lords. Page 14 of the learned penal counsel for BDA in more than justified in conduct proviso to rule 13 of 1894 is not invocable. Ordinary proviso is treated as exceptional general form incorporated in the main. The petition should broadly fit into the norm first and then issue discussion of clutches. Here I am a scheduled caste person, my lord, as entitled for installment. The learned judge has misread this thing, my lord. This observation runs counter.
Where is your averment in with regard to proviso in your petition?
In
you will
Petition where we have.
in the petition, my lord.
13 proviso to
Yes, yes.
13.
Please, my lord. At prayer B, my lords. Rule 13 BDA of the BDA rules refers to condition of allotment manner which allottee has to pay the title value. According to Rule 13, the allottee has to pay the balance within 60 days from the date of service after deducting the insurance. If the balance amount is not paid within so and so, the amount shall be raised in %. I have raised that, madam.
Now let's see the proviso. When was the allotment made?
In the next paragraph, he belongs to schedule.
When was the allotment made?
Date of allotment, my lord. Was on 21/2/2002.
When did you made the
amount was written on 21/11/2002.
when was the first representation?
Then from 2003 is giving continuous representation, my lords. From 2003 is giving continuous representation. He has an approach to Chief Minister, BDA Secretary. Everybody has gone.
You appear for the state. What is your submission? BDA. Just see this. But this proviso is only for payment of money on allotment. Not in a case where you paid, you took it back and you want to again repay it. That's not the case.
I'll put it this way, my lords. I went to them. I said, I have no money. That is the reason you return the amount. At that time, the official should have disclosed to me that since you're a scheduled caste person, you have got a benefit of paying in installment. That was never brought to my notice.
See, then
I took the amount in good faith. That is one point, my lord.
Please. Your whole case is because of the education of your child.
Yes.
That's the ground.
Yes, my lord.
So so for certain other reasons, you said I want. So even if he had told you, look here, you have this benefit, still you would say, look here, I want my money to be, for education purpose of my child. You would have still said so.
I have clearly mentioned, my lord, that I want the money for education of my child.
Right. So this proviso would not come to your help.
That is one issue, my lord. The other, this man, knowing that, he thereafter made 9 attempts.
It's all right.
Now, my lord, my submission is, my lord, that it's a officer's duty to bring to notice benefit extended to scheduled caste people. That has not been brought to his notice.
You're not
He has lost
understand-
the sight.
Even if he had brought it to his notice, necessity for the education would still be there.
No, now, my lord, necessity, then I would have made because the provisor provides me to pay installment for 3 years. Had it been told, my lord, yes, I agree. I agree, my lords, I have taken back the amount. I am not disputing that. But the fact remains, no, but the fact remains, my lord, that I should have been given the benefit of installments. I have lost it. Thereafter, my lord, I have made 9 attempts. Because I have cancelled, my lord, they have not given the plot. At least that be considered, some seniority may be kindly given, my lord. 9 attempts, I am 70 years old now.
There may be so many cases where people could not pay the money. Everything gets open.
Please, my lord, may I consider the seniority quota. Something, my lord, that is the reason I said there is one judgment, my lord. I'll just look into it. I'll make my submission.
No, that we'll ready to consider.
That's all, my lords.
So only judgment.
Only judgment,
Yavadu?
only judgment.
I'll place the, I'll place the judgment, my lord.
Okay. At the request, we have heard the counsel for the appellant for some time. He seeks an adjournment to place before the court a judgment in support of his stand. At his request, read.
Your lordship, can one more submission like this. Seniority, how should be considered, my lord? I will have to make one more submission.
It's a non-issue.
Because of my 9 applications are pending, my lords, not been granted, though later applications have been considered. Right of shelter, but end of the day, the poor man who because of government company closed, he lost his job without pension.
Just show us the judgment. Thank you.
That's all.
110. Serial number 15. 15, Shri Mahesh Upin.
I have filed this application seeking extension of time for supply substitution. 1310, Lord, the Honorable Court was pleased to grant 4 weeks. Not able to comply.
How much time?
Please.
4 weeks granted to remove the office objections.
511. 16.
My lords, I am appearing for the appellant in this matter, my lords. Lords, there is a delay of 598 days in preferring this appeal.
What is this impleading appellants?
Lords, since I'm not a party in the writ petition.
Who was not a party?
The appellants, myself and my.
There are 5 others.
Yes, my lords. Since I was not been made a party by respondent 1 in the writ petition, I have filed an impleading application.
You see.
OS is pending.
Lords,
They are praying for the facilities to release the statement which was pending. Because they had order for release.
No.
They by them, they are saying that.
Who were they were the appellant? No, who were the petitioner before the single?
respondent number 1, my lords. My lords, the impugned order is at.
Respondent number 1?
Yes, my lords. The impugned order is at page number 20, my lords.
No, respondent number 1 was the petitioner.
Yes, my lords.
Why did they challenge it?
My lords,
Now,
that
that's a
writ petition.
trust. That's a trust.
Yes, my lords. Respondent number 1 filed the writ petition seeking to release the sale date which was pending registration, my lords. But this particular impugned order was secured before this honorable court by suppressing several material facts and documents, my lords. And also neither the state nor the respondent number 1 put forth the actual facts and material before this court, my lords, while securing that impugned order.
How are you concerned?
My lord, the property is my property, my lords, where I am in possession.
No, how are you related with the trust? Is there any relation with the
No,
trust?
my lords. The appellants had executed a GPA in favor of one person without the clause of sale transaction, just to take care of the property. the GPA holder hand in glove with the respondent number one executed a sale deed.
Who had executed the GPA?
Myself, my lords, in favor of the GPA holder. And there is no clause for sale, my lords. My lords, but this particular order was secured by suppressing, by playing.
But what is the suit which is pending?
My lord, the one suit filed by me is for
injunction.
Declaration and injunction, my lords.
Against respondent.
Respondent number one and the GPA holder, my lords.
For both.
For both, against both of them, my lords.
But then why don't you file a review before the learned single judge?
My
You
lords,
should, you should actually. Get it? Otherwise, based on your rights are getting affected.
my lords, yes, my lords, review, I believe.
You before the learned single judge, look here, I am a necessary party or a proper party. I should have been made a party for these reasons. There is a
Yes,
suit,
ma'am.
you have filed it. You will work out your rights in the suit. But today you would be considered because of these directions.
Yes, my lord, but the order is obtained by playing fraud upon this court now, my lords.
So better would we go and file a review.
My lords, review.
Why not?
A little difficult.
No, but in any case, it will be allotted to some judge.
My lords, I request this court to kindly hear me, my lords. The order is obtained by playing fraud upon this court and by not making me as a party, my lords.
Legal issue notice only. Where is your application seeking permission to file this appeal?
My lords, it is at page number 121, my lords. Starts at
That's
120.
under order 1 rule 10.
Yes, my lords. Starts at page number 121, my lords. The affidavit is at page number 124, my lords.
Sure. Let's see your appeal. Where do you say in your this thing? Let's see your affidavit or let's see your petition.
My lords, yes, my lords. My lords, the petition starts at page number 6, my lords.
Which paragraph you say? That it has been done at your back?
Yes, my lords. My lords, para 15 onwards, my lords.
What was the para?
Para 15, my lords, page 12.
Whether the stale deed has been released?
It is released, my lords.
So what really survives in this?
My lords, but the impugn order is secured by playing fraud upon this court, my lords. And also I have not been made a party. Because of the release, I have been put under distress, my lords. My lords, there was one writ petition filed by respondent number 1, my lords. Challenging, first he had filed a writ petition in the year 2014 seeking to release of the sale deed. Thereafter, that particular writ petition came to be withdrawn with the liberty to challenge an endorsement. And again, in the year 2019,
But tell us one thing, did you seek any prayer in the suit
my lords.
with regard to the sale deed which was executed by the attorney in favor of respondent number 1?
Yes, my lords.
You have seen it?
Yes, I have sought for a prayer declaring that the sale deed is not binding upon me.
So then even assuming for a moment it has been released, the substantive prayer against the sale deed is there now. Let's assume for a moment.
Yes, my lords.
Your prayer is accepted. Let's assume.
Yes, my lords.
What follows? The
Let's
very
see.
substratum, very foundation of this order goes.
My lords, but
Issue notice. The issue.
my lords, I've also, IA number 2 has been filed seeking to maintain status quo, my lords.
First serve them.
Yes, my lords.
Serve them.
Yes, my lords.
Okay, but in any, see, otherwise you should all pray in your suit. This also prayer.
Yes, my lord. My lord, there is a prayer
And
seeking for
mind it,
declaration.
mind it, you are right. Today, this is only release of that sale deed. You have actually challenged the sale deed there.
Yes, my lord.
You actually challenged the sale deed there.
My lord, the first, my
And
lord,
we,
if I-
we go further. Even the direction to release sale deed will have no bearing on those proceedings. For the simple reason, that's what we are coming. Even if you succeed there, the very sale deed goes.
yeah, my lord, I agree, my lord. My lord, if I may, my lord, if I may give in to.
Last one was issued by the sub-registrar saying that it is pending, we can't release. As per that, he is at the direction from the court. That's between the petitioner of that suit and the state.
Issue notice.
My lord, if I may give in to.
They serve the other side, issue notice.
Yes, my lord.
On the petition, all your applications, everything.
Yes, my lord. My lord, the date.
Returnable on.
A date. may be-
510,
We are giving the date. Next,
Obliged.
17, Shri Jayakar Shetty.
you have removed the office objection.
You have to
My
file
lord, my lord, there is, my lord, there is an advocate submission, my lord. The impugned order was obtained by the appellants through RTI, my lord. They have filed the original RTI application. RTI copy.
What was the objection?
My lord, there's no objection as such, my lord. The objection was only that the certified copy from the court is not being filed, but the impugned order was secured through an RTI application, my lord. They have filed the original RTI, my lord. It may be overruled, my lord.
The learner counsel for the, just say this.
Yes, ma'am.
Appellant submits that the office objection is that a certified copy of the order passed in the writ petition has not been furnished. He states that the appellants herein were not party.
Yes.
Before the learned single judge. Full stop. They could secure the impugned order through an RTI application.
The original RTI copy has been filed.
The original RTI application has been filed on record.
Yes,
Okay.
the RTI order obtained through RTI.
The information given under the RTI
Yes, ma'am. Yes, ma'am.
has been placed on record.
It may be overruled.
Full stop. No, have been secured through a application under RTI. Let's say that only. Full stop. According, in view of the submission made, the objection is overruled.
Obliged. My lords,
Yeah, you can, in view of the, just say this, in view of the submission made, comma, we have heard the learner counsel for the appellant on the appeal as well, then say issue notice. So, yeah, we know that. Delay is there, 598. So and so accept notice for 2 and 3. Let notice be issued to the other respondents.
respondent number one.
Respondent number 1, returnable on. Next.
Much of.
Serial number 17, Shri Jayakar Shetty.
For the petition, already I paid the process payment. 27th/8,
Let notice be
2024.
issued to the respondent number 1, returnable on.
11. 18, Shri Rajesh Kumar.
My lord, for the petitioner, my lord. My lord, the office note is on submission with reference to an order of 19/6/24, which I have referred to in my prayer.
But why not National Commission?
My lord, why I brought it to my lord is there's an error on the face of it. My lord is pleased to see the order sheet.
You should go.
Please see the order, my lord. Just for a moment, my lord is pleased to see. My lord, the order sheet is at ink page 49. Ink page 49, my lord.
Yes.
Yes, my lord. My lord, 2/5/24, both counsels present for complainant's argument by 18/6/24. I am the opposite party, my lord. 18/6/24, CC is allowed in part, white separate order. My lord, on the same day, what happened, my lord? My colleague, my lord, to reach the court took a few minutes delayed. Please see ink page 50, my lord. 18/6/24 itself, I sought for a recall. On the same day, I said that, and throughout, my lord is pleased to see the order sheet. I've always been there. 18.
So let go there.
My lord, what happens is, my lord, I have to go to Delhi and I have to deposit money, my lord. The only aspect, my lord, is, please see even the operative part of the order, my lord.
There is no reason.
My lord, please see even the operative part of the order, my lord. That's at ink page 24. My lord, the company and the directors are held personally, jointly, severally liable. So, my lord, and there's a section 95 moratorium as against the company, which the learned
under the IBC.
Yes. So there's a moratorium. I would have placed that.
What about the directors?
As against the directors, my lord, there, There's a,
You will plead everything there.
my lord, most respectfully, my lord, 19.6, my lord.
Did you point out this to the State Commission?
Please see, my lord, in
Oratory.
page 23, it is found from the affidavit evidence of OP1 at the bottom, my lord, that the company of OP1 is under, that's factually wrong, because it's not the company, it's the principal company. I'm a 100% subsidiary. The main company is under CIRP. The directors are under section 95. So there's a moratorium. That is subsequent to the affidavit filed by me. Learned counsel of the complainant has also brought to the notice of the commission that in such similar matters, my lord, there was a moratorium.
Moratorium qua who?
Qua the petitioner number 2 and 3, my lord, before my lord. Petitioner number 2 and 3, who are the directors of that company, at the instance of State Bank of India, section 95 proceedings have been initiated before NCLT Bangalore. As far as the main company, my lord, of which petitioner number 1 is a subsidiary, it's under liquidation. And liquidators.
But that would be extended to petitioner number 1 when the main,
Yes, that's what we have stated, my lord, factually. We have stated that since the main company is under liquidation, the subsidiary will be represented by the shareholder who is the resolution professional or the liquidator. And as far as petitioner number 2 and 3 is concerned, there is a section 95 application. And my lord, the moment the application is filed, moratorium kicks in. That moratorium was after my affidavit of evidence was filed by State Bank of India. And despite that, my lord, the learned tribunal takes note of the CIRP and says a joint and severable. And throughout, my lord, I produce the order sheet.
so you are saying even they can't proceed against 2 and 3?
Yes, 2 and 3. And throughout, my lord,
1 also, 2 and 3 also.
yes.
Where do you say this, what the commission has noted in your pleading?
Yes, my lord. My lord, in my affidavit filed before the authority, ink page 34, it starts. My assertion is at para 11 at 11.1 at para page, ink page 39. 11.1, page 39. And also,
I don't know, will this averment suffice? What about the directors? What about 2 and 3?
well, no, that was subsequent to this affidavit was filed. This affidavit was filed on 15/12/22.
But there was no occasion for you to tell the commission.
That was in 23, my lord. I did not submit, my lord. I did not. It was in 23.
And in your absence, they decide the petition.
Same day, my lord. Throughout, my lord, please see the order sheet. I looked at it to see my learned colleague's conduct also. He has been there throughout, my lord. Both councils present on all dates, except that date I reached 10:15 minutes because of the traffic. My colleague has filed a memorandum of facts saying on the same date, not even the next date, 18/6.
But otherwise, the remedy is
Yes, my lord. My lord.
before the National Commission.
My lord, I was just referring to the judgment of S.N. Mukherjee's case.
It's not a case of inherent lack of jurisdiction.
Not that, my lord, error on the face of the record.
That's the only thing is the State Commission, at least in the facts, could not have.
That's all.
That's all. We'll just serve the other side. Let's see.
Great, lord. My lord, let them not take any precipitative action.
What action they have taken.
No, not yet, my lord. They will file under section 70
They
because it
finally
has
come
an
back.
arrest
If
provision.
you notice, returnable on. What are the objections here?
My lord, I refer to an order dated 19/6/24, which is not reflected in the order sheet of the court below. Because what happened is 18/6 itself, I filed my application for recall. And on 19/6, my lord, I filed an application for, it was put up on 19/6. But that is, neither of those are reflected in the order sheet of the court below.
You are
My-
challenging order of 18th.
18/6, that's the main order.
But why didn't you file it 19th order?
My lord, there's no, because I obtained the entire order sheet.
But what order has been passed on your application?
Nothing, my lord. It's in fact, ink page 49. There's no reference to either my application. Please see, my lord. 18/6/24. There's no reference. This was applied on 23/7/24.
They have stopped here.
Yes.
That's a fresh application. Are you saying that no order was passed on the fresh application?
Yes. Yes.
So there must be something. They say with no merit dismiss, there must be something.
My lord, when we applied for this, even I was under that impression, but nothing is reflected in the order sheet. What the honorable court below said.
Or in the file, or in the record.
Please see, my lord, the seal is there on the left-hand side, 18/6/24. Below, the learned counsel for the complainant has also acknowledged service of copy, and the seal is also there. It would be in the file, but what I'm told is that if you want to argue right now, I'm not going to take it on file. Unless it is recalled, my lord, we could have advanced our arguments. Nothing is stated in the order sheet.
No, but was your application taken on record?
My lord, it was taken by, I mean, what I could fairly say, my lord, it was placed before the honorable court below. It was given. But from the order sheet, my lord, it doesn't show.
Then how would you say that you had actually filed an
My
application?
lord, the seal is there, my lord, left side.
What does it say?
That it's acknowledged. First is the opposite side has acknowledged it. On 18/6/24, the bottom, received with objections, advocate for complainant, 18/6/24. This must be the seal of the pending section, my lord, the pending section of the court below. The left side seal in Kannada.
What does it say? Page 49. This.
The final order will be sent to the complainant and the respondents.
They say issue notice.
Therefore.
Twenty-two, 10. 19.
Appear.
Yes.
Lord, the petitioner is an employee of the Lord corporation, Bharat Penal Palike Lord. He is in the cadre of executive engineer, which is a group A senior scale Lord. While he was on deputation to Chitradurga Lord in the year 2013, her mother executed a gift deed in favor of her son-in-law, husband of the petitioner, regarding site number 293 in Durga. Accordingly, Lord, this she transferred Kata as a commissioner of the municipal council. Then, Lord, sisters encouraged the mother to file a suit. Sisters, daughters, other two daughters, instigated the mother to file a suit. The suit is pending. In the suit, Lord, one Uma Devi also impleaded, filed a counter suit, counter claim. It's a suit only, stating that the gift deed is not binding, declare that it's null and void. Whatever Kata is there, please cancel it. She also lodged a complaint before the Lord Lokayukta, alleging that please cancel the sale deed, gift deed, Kata, everything. Kindly see the complaint made before the Lokayukta, page 98. My Lord will find English translation, page 104. Vacant plot related to me, my Lord will find, measuring 30-40, located 5th block, so and so, transferred through gift deed by Mrs. Bharati to her husband, K. Mahesh, originally acquired from her mother, Lalitama. Lalitama, mother of Bharati, unnecessarily creating a nuisance. They are trying to build a house with permission, vacant, belongs to me. Then, Lord, her complaint in English also will annexure L, in this English translation. My Lord will find page 108. her prayer before the Lokayukta is, please take steps to cancel the gift deed. Page 118. Based on this, my lord, the deputy registrar in charge, my lord, page annexure M, page 121, issued observation note calling upon the petitioner to submit her reply. She replied, annexure N, my lord, English translation. Based on that, my lord, the Lokayukta recommends for entrustment of inquiry to the Upalokayukta. Lord, government by order dated 18/1/2022, P, annexure P, not entrusted the matter of inquiry. Thereafter, Lord, the charge memo is issued, annexure Q, on 13/2/22. Then, my lord, recommendation inquiry report is submitted holding the charge is proved, annexure Lord S, and T is the recommendation of the Lokayukta for imposing penalty of compulsory retirements. And then Lord 217 is the second show cause issued by the government. My lord, why penalty of compulsory retirement shall not be imposed if I don't submit.
Which page is that?
Page 217. That is issued by Under Secretary, contrary to Rule 19 of the Karnataka Business Transaction Rules. But I am before your lordship. But my limited submission is, my lord, in a matter of like inquiry, I must make out a case that the very initiation is without authority of law. Consequently, entrustment is also without authority of law, and all orders are liable to be quashed. But I have raised the first contention, Lord. The complaint, not observation note, is issued by Deputy Registrar. My lord will find annexure M, page 122. Lord, under section 9T B of the Lokayukta Act, it is, my lord, observation note shall be investigated by the Lokayukta serving a copy of the complaint on the delinquent official. If it is not done, entrustment order, charge memo, all consequential action shall go. That is what this court interpreted. In
No, just one.
Yes.
Can you just repeat that submission?
observation note served by the Deputy Registrar is one without authority of law. Under the Karnataka Lokayukta Act, section 9(2)(93)(a) mandates that the copy of the complaint shall be forwarded by the Lord Lokayukta or Upalokayukta to hold preliminary investigation.
To be forwarded.
Yes. I read, Lord, how it is worded in the book, statute book, where the Lokayukta or Upalokayukta proposes after making such preliminary inquiry, it is preliminary inquiry, Lord, as he deemed fit to conduct any investigation under this act, he shall forward copy of the complaint. And in case of investigation suo motu by him,
Which provision you are reading, Mr.
section
Bhagat?
9(3)(a).
Shall forward a copy of the complaint?
Yes, Lord.
Initial
And-
note of opinion recorded
Yes.
by him to investigate under this.
Yes.
As the agreement to the public servant or the competent.
Yes.
So
Then,
this,
Lord-
this was forwarded at annexure M
Yes, Lord, by the Deputy Registrar
to you. By
To
the
me.
deputy registrar.
to me.
But how would you meet the paragraph 2 of that letter?
That has been interpreted by this court, the very section 9(2)(93), my lord, kindly annexure Y. My lord is right. Asking the question, page 249. The very provision is interpreted by this. My lord, will find the question before the court was division bench in 249. my lord. Kindly see, my lord, in that the question was examined this, my lord.
But there was no charge sheet in that.
Yes, there was a charge memo, entrustment order, both are question, all are question.
No, there was no charge sheet there.
Yes, my lord.
It was,
Yeah.
if you see this,
Yes. There's a charge memo, entrustment order or charge memo, both. I'll read that also. Brief facts. Lokayukta proceedings were triggered by the complaint on Sri so and so, an advocate's allegation that certain land records were meddled with body of lands was made unlawfully. That complaint was referred to the Assistant Commissioner Koppal. Preliminary inquiry in terms of 9(3) of the Act. The Assistant Commissioner in turn forwarded the copy of the complaint to the petitioners, has filed objections, had submitted a preliminary report dated 25/6/2015, recommending for investigation. The Honorable Lokayukta, Upalokayukta, having investigated the matter, submitted to government section 12(3) report dated 23/2016, recommending a disciplinary.
who had forwarded in this case?
Yes.
Who had forwarded in this case?
Deputy Registrar in charge.
In this case also, in this judgment also?
Different officer.
Where is that? How-
I'll show it.
But tell us one thing, Mr. Bhagat.
Yes.
But then why did you submit it to the jurisdiction? You should
Yes.
have taken the point.
My lord is right, but no doubt. But the question is,
Find it. What is the stage now?
no stage is second show cause notice.
That's right. You submit to the jurisdiction of Lokayukta without any objection.
There also, my lord, in the very case also, Lord charge memo is issued. He was facing inquiry. Both orders are pushed. Can you see that also?
Right.
My lord is right.
On an issue of law, yes, you can argue that there is no estoppel against law.
Certainly, estoppel against law will never arise, according to me.
But the fact remains, you having submitted to the jurisdiction of the Lokayukta,
Yes.
participated in the proceedings,
Yes.
allow the proceedings come to
Yes.
this stage,
Yes.
and see your reply to the show cause. We want to take you to
I have
that.
not, my lord, filed reply at all.
You have not,
No, my lord.
but you have given one communication,
Yes.
which we want to show it to you.
Certain documents are not required to be, that's what it is. Yes.
Here also,
Yes.
you don't challenge the authority of Lokayukta.
Right.
You don't, in this letter also,
Yes.
the submission is, at no point of time, the authority of Lokayukta is challenged. Or the proceedings have been challenged, at no point of time.
But in the present writ petition, my lord, I have questioned the entrustment order, not entrustment order, but consequently all proceedings are liable to be questioned. Because this court.
1 minute.
Yes. There are three legal points. Number one is this. The entrustment order, not without authority of law. Why? Because she is a class 1 group A officer, senior scale officer. Under the business transaction rules, it is not, it comes under second schedule, where particularly Lord item 8 mandates that it must be not authenticated by the chief minister. Otherwise, they cannot entrust or pass an entrustment order.
Then why don't you do this, Mr. Bhagat?
Yes, my lord.
You file, you have sought 45 days time
Yes.
to file a reply.
Yes.
File your reply, take all objections. Take all objections. Even possibly you can rely upon this judgment. Let the authorities come look into it.
My lord, before the authorities, my lord, I don't think, my lord, my lord is right in suggesting, but at the same time, my lord, I am before your lordship contending, my lord, these are the legal questions, my lord, to be decided by the court, not by the authorities, according to me, my lord. There are other legal grounds.
We'll just come.
Yes.
What was the order in that judgment?
Yes, my lord.
Who had forwarded the entrustment? Who did
Additional
the entrustment?
Additional registrar forwarded in that case. Additional registrar. He is deputy registrar, one cadre below him.
But there is no denial that deputy registrar has forwarded on the directions of the Upaloka.
No, no. In that case also same. In that case also same. That is an order in the file.
Page 254. What do you say?
Second showcase notice. Normally, the showcase notice cannot be.
Right, that's a normal law. But
Yes, where Milord has been referred by the Milord has been counsel. Milord, in which Milord has been entrustment, at the time of entrustment itself, Milord is questioned. Here the case, Milord, all.
how do you say it so? How do you say so?
It is there, Milord. Entrustment
That's
is-
right. So what we are understanding you is there was only entrustment at that time. He had come to the court. In that case, no further proceedings took place. How do you say so?
Milord, this is the Milord case.
I know.
Produced by by- Annexure Y Milord produced by the Milord at the.
Annexure Y we have.
Right. In which Milord at the stage of preliminary stage, entrustment Milord at the question.
Okay, yes, Mr. Bhagat. In fact, that's what we have also posed to you.
Yes.
That was only at the stage, preliminary stage.
Yes.
But here it's not a preliminary stage. You have submitted to the jurisdiction of Lokayukta, allowed the proceedings to work. And even till the filing of the petition, no challenge.
There also, my lord, entrustment order, charge memo also issued.
Pardon?
Charge memo, charge sheet also issued.
But no proceedings thereafter.
No, my lord.
That's the difference.
That is the stage. Number one, my lord. Number two, my lord, it is a pure property dispute. Under section 8(1)(b) of the Karnataka Lokayukta Act, there is a complete bar.
You're right, Mr. Bhagat.
My question is whether Lokayukta can decide the property dispute.
No, but tell us one thing.
Yes.
What prevents you to put everything
My lord is right.
to the Lokayukta?
I am not able to answer that question because it is a case, my lord, my lord, I have come at the stage of not second show. I am not there, my lord.
So,
but the question is now, if it is without duration, at any stage, estoppel against law may not arise. In my lord has in Delhi High Court decided very question and held, my lord. In such case, my lord,
that's the point, and this is a settled position.
Yes, Lord.
Having submitted to the jurisdiction, we say nothing. What is the effect of the officer submitting to the jurisdiction? What is the effect? We will not say anything. Because the proceedings are still pending before the Lokayukta. No final order has been passed.
Before the government.
Before now it is government. Because the government is the appointing authority.
Yes.
That's right. Oh, we take it before the government. So it's pending before the government. You will take all places which are available to you, both on facts and in law also.
My lord, when I am making out a case, when jurisdiction is involved.
We only think that's a difference, slight difference between that judgment.
No doubt. There is slight difference on facts. But at the same time, my lord, law is settled. But I can understand law is not there. Law is settled by this.
We are more concerned when it's not a question of concern. What is being seen is at no point of time, even after show cause notice, even reply to that is this objection is taken. We'll tell you why.
Yes.
If you had taken an objection at the first instance, possibly whatever was the, would say the defect would have been cured. But
so far, this direction of this court till today, my lord, only additional registrar is issuing the order.
Pardon?
Even now, my lord.
Even they do
yes,
it.
even now, my lord. even though this judgment is rendered far back, even no, my lord, I will show your lordship, my lord, even the last week also I come across the same question before the tribunal, before this court, same thing. That is not, my lord, they are not improved. They are not even.
No, but we are only thinking this. If you rely upon this judgment to the authorities.
Yes, Lord.
Look here, this is the position now. And the court, in the facts, like in this case also, when the entrustment was by a deputy registrar, not by the Lokayukta or Upalokayukta, then the proceedings may be irregular or maybe illegal, whatever terminology you want to use. And the Lokayukta would consider it and then proceed further. Why we should not, or at least we want to elicit answer from
She
you.
might be ignorant of law, my lord. And when she consulted by our office, my lord, this has been, my lord, I found that, my lord.
But surely you will rely upon this judgment, which has been relied upon by you, by the coordinate bench.
My lord, I cannot go back and now to Lokayukta and say.
No, you can't go to them. You have to tell the
But
government.
the question is now, two legal questions, my lord. Entrustment, government will not examine, my lord. Government will never examine anything. If she, but kindly he show cause notice, they say, propose a penalty also as per recommendation. But kindly appreciate this, my lord. I can understand, look here, Lokayukta recommendation and copy of the inquiry report will be given to the delinquent official to have his say. But in this case, why recommendation Lokayukta for imposing penalty of compulsory shall not be imposed if you don't submit reply?
But that's a tentative decision, Mr. Bhagwan.
Right.
It would be tentative, subject to they eliciting a reply on the show cause.
Whatever may be, can they, my lord, prejudge? I can understand. Look here, inquiry report is that, recommendation is that, please reply. That I agree. But at the same time, lord.
Where is the show cause?
Find it, annexure B. Show cause notice, the lord will find the annexure B, page 217. And is he annexure B, my lord?
Yes.
Yes.
But I cannot tell the government that, look, Upalokayukta committed a judicial error. Please remit to the Upalokayukta. But government will not take, because government is bound by the recommendation. Not 100 out of 100, not 99, not recommendations are accepted, orders are passed. Practice is this. Not, I have come across lot in my experience, not one or thousands of order passed by the Lokayukta recommendation. Blindly, not government will accept it. It is written at large. The injury going to be cost to me is a grave. But I am retiring. I have a 10-year service. I made to retire compulsorily. I am too young to join new employment. Remedy is when touching the jurisdiction at any stage, according to me. Court may rescue me, because jurisdictional error is not one. 8(1)B Lokayukta has no power at all to go into the property dispute. Kindly appreciate this, my lord. Kindly see 8(1)B. There are three legal questions I have raised, not one. One is this 8(1)B, kindly note. Where there is a remedy under law, Lokayukta shall not investigate any complaint or apology. But government is now, the authority now take a decision, my lord. Therefore, stay the further proceeding on extra UV. Lord, here it, Lord, fix a date. Anyway, it should be de novo.
You appear for which respondent?
First respondent.
Who appears for 2 and 3?
That sounds.
One, my lord, they have served the, my lord, advocate on record, also give a copy to Ashwin Haladi. Ashwin Haladi. For BBMP, my lord.
You want to hear the rest 2 also?
Yes, my lord. My lord, we hear it.
This Arbati will appear.
Mr. Abati, you appear for? Take notes.
Threes.
Already issued, my lord, already issued. This is for considering interim period test comment.
This was not served on the 2 and 3. Has it been served?
But I have taken test, Lord. I have taken test. I have also served copy of the Lord. In fact, advocate on record served it on both BBMP as well as my Lord Penal Council on the very day. My Lord issued notice. Besides that, I have taken test. Therefore, I have served they have served the penal advocate Ashwin Haladi for Lokayukta and Mrs. Pinchana for BBMP. Both Lord they have served, apart from taking steps.
You have served the copy of the cards.
We have served the government also additional copy. Memo is there, Lord. 24/8.
Yes, now you appear for 3.
I think senior has served it on my colleague. I will take instructions, my lord. Your lordship may post it sometime next week. My lord.
Who is the counsel on who you have served?
Ashwin Haladi.
I will inform. Because his name is not shown, I think.
Who is the counsel, Mr. Bhagwat, who has served?
Again, they have served it on Srimati Sinchana, my lord.
I will ask him to serve one more copy to him, my Lord. The note
Also in the panel, my lord, I will also take. note.
Sanjeev,
I'll
Sanjeev.
inform her also. I'll also inform her.
No, we will copy. I will ask him to serve one more copy, my Lord. Now itself, for him also.
Yes, we then informed those counsels on whom they have served.
Yes, ma'am.
So that at least they can hear, we can hear them also.
Yes, ma'am. We'll.
Just say this, we have. We have heard Mr. Bhargava, the senior counsel, the on the 23/8/2024, we had issued notice to respondents 2 and 3, returnable on 3/9, returnable yesterday, returnable yesterday.
3/9.
There is no appearance even today. There is, Mr. Bhargava submits that in terms of order dated 23/8/2024, the advance copy of the petition was served on the standing counsel for 2 and 3. What are the names?
R3, Ashwin Haladi. Hello?
What about R2?
R2 is not served. They are not served.
Then,
But I will ask him to serve a copy on him.
The name is not shown. My colleague's name is not shown. Otherwise, he would have been present here.
His name is not shown. Name is not shown.
but you can inform.
I will, he was here, not, I will inform straight away.
BL Sanjeev. BL Sanjeev. So Sanjeev appear, who is the counsel for the BBMP?
Lord, Mr. BL Sanjeev is a counsel, my lord. If it is not served on Ms. Sinchana, my lord, then I'll take notice.
My lord, may kindly direct him to take. Not served. Not served. Not served. That's what they say, my lord. But he is a formal party, BVMP. We have nothing.
BL Srinivas BS.
So Srinivas BS, who appears for BL Sanjeev, states that can accept notice for responding interview. To stop at the appropriate charge that party will also take a look at shall inform Mr.
Ashwin Haladi. Haladi. Haladi.
9th of
September.
2024. And asking him, requesting him to be present in the court. We'll hear you on this, Mr.
Lord, by that time, Lord, I will be.
What is the stage?
But the notice, my lord, they are not replied. But approach.
So you are not, till 9th, you are not going to pass any order.
Let them undertake, my lord. I am happy.
Taking, my lord, they are not, my lord,
No, but Mr. You sought 45 days time.
That also expired, my lord.
When?
My lord, that also expired. They have no say. Kindly he order dated 10/6/24, my lord. 10/6/24.
No, in July.
July, my lord. July,
45 days will expire when?
Lord, I'll tell you. 16/7, 16/8, 16/8, Lord, 38, Lord, expired, Lord. That also. Kindly, Lord.
What are your instructions?
On 6/8/2024, my lord, the 20 days is granted, my lord, to file reply.
That also expired, my lord. That
So
also.
now what action you have taken?
But not yet, my lord.
You have not taken action.
Not yet taken any action, my lord, that the.
Till 9th, you intend to take any action? So you are not going to take action by 9th?
No.
Monday? Okay, we'll have it on Monday. All right, Mr. Bhargava, we'll have it on 9th.
My lord, let it be in order, my lord. Whatever they say, my lord.
Now, no. Don't pass any order. We are not passing any order till 9th when we hear the matter. Okay, just tell the officers. Please. Okay, we'll have it on 9th. Mr. Bharati just informed.
I will.
Whosoever appears, but there should be the present representation must be here.
Your lordship may also direct the registry to show the name of Ashwin Haladi.
Mr.
Ashwin Haladi for R2.
Mr. Ashwin Haladi for R3.
R2.
No, R3.
R3. I'm sorry.
Mr. Sanjeev for R2. BL Sanjeev.
It's a G for R.
R2.
I Much.
Great.
Number 20. Prashant Gowda.
Your Lordship, I appear for the petitioner, Your Lordship. Your Lordship, in this matter, the petitioner is hospitalized, Your Lordship. We had to seek instruction regarding the revision petition which is pending before respondent number 1. A short accommodation may be granted, Your Lordship. We'll get back on that, Your Lordship.
And there is a case of preliminary finding of malafide, misappropriation, misrepresentation, misconduct by the 12-1 report of the Honorable Lokayuktha.
At 12-1, the court must interfere. Who is the counsel?
Not for.
12-1 is a recommendation, na?
Yes, ma'am.
After the inquiry is over?
Not after the inquiry. No, this is a preliminary stage inquiry. Lord, we have found some criminal activities. So, Lord, we have recommended the registration of pursuing the criminal case. We have not done anything. We have recommended to the cooperative societies, to the registrar of cooperative societies to initiate criminal action. He has filed a representation to the jurisdictional police. They have taken the matter forward. That is all that. This recommendation is just a very, very preliminary stage, beyond which another 2 more stages have taken place.
Beyond which?
2 more stages have taken place. Based on acting on our recommendation,
Who is the counsel?
Your Lordship, my seniors has instructed me that
What happened to your senior?
Your Lordship is not present, Your Lordship. He's not present.
Right? So is it you are present?
He's not physically present here in Bangalore.
Well, he can present virtually, we'll hear him.
I'll just seek instructions, Your Lordship.
What instruction?
I'll just ask him whether he's. Your Lordship, may I have it up to 2 weeks?
Straight order.
yes, stay. That is the government advocate has filed a IA for recall, vacating, sir.
There was 300 and hard acres, my lord. Government has fixed 150 crores as a government bid. It was sold for 50 crores.
2 weeks, Your Lordship. Okay, Your Lordship.
We'll adjourn it for tomorrow. No, don't put any conditions, please. Not like this. We'll give it next week, we are saying it. Should not add on what the court has said.
Indeed.
Everything.
But may I also seek indulgence, my lord? There is another writ petition filed by, my lord, the DGO here. In his capacity as the representative of this cooperative society, my lord, that is, there also, my lord, an interim order is there. That could be.
The thing is that one has to do the state or whatever it is. We don't know that this court has jurisdiction or not.
My lord, not as a roster, my lord, because it is before honorable single judge.
Oh.
But it is arising out of, my lord, the same set of facts, my lord, and the 12-1 report.
How that is listed there?
Not because it was challenged, not your lordship, it was challenged, the roster is the CS, Cooperative Society roster, so it came before. Here, my lord, in this writ petition, 12-1 report is challenged, that's how it came before this on report. Now that, in fact, a copy of that.
If you have to move, you have to be on the.
Very well.
Whatever in the
I will.
process. It
Not
is
in-
not our roster, we will not say anything.
Very well. Very,
For you to take whatever. you-
very well.
Just say next week any date. Let's see.
11-9. 11-9.
11-9.
Much obliged.
Next.
Your Lordship, interim order may be extended, Your Lordship. Much obliged.
21. Sir, 21, sir.
21, I appear for the appellants.
Yes.
And, the IA, one my lord for seeking leave of grant. The first petitioner before the Honorable Single Judge my lord, 1 T Venkat Swami died my lord, therefore his legal representatives were filed this appeal.
You file your written submissions. Okay. You appear for all the respondents?
Lord, notice has to, notice not at order, my lord, in respect of respondents 3 to 8, 3 to 12, 13.
Who were the petitioners?
Yes, my lord.
Who was one petitioner number 1?
Petitioner number 1, father of the appellants number 1 and 2 hearing.
Expired.
He's expired, man.
One and two.
One and two. 7-11. Number 22, Sri Muralidhar.
For the appellant, my lords, pray for 2 weeks' time, my lords. The senior is unavailable today. Two weeks' time may be granted, my lord. Senior is not available to.
What is the amendment? Is there any amendment has come now? In this act, PTCL act. Yes. What is that amendment?
Amendment is that, my lord, limitation will not apply to file an application for restoration in respect of pending cases.
What is the date of the amendment?
27/7/2023.
So there would not be any limitation.
Yes, my lord. Earlier, there was reset of cases will become in that way. First one, reset of cases will come in that way. First one is there was no rule period, my lord. Till 1935, there was no rule, my lord, in grant. Thereafter, till 1978, there was a rules. Rules was framed by the concerned revenue department for particular period. There will be a clause to be initiated for non-alienation. After 1974, the Act was 79 Act was came into force. Thereafter, alienation may not be taking place, and court to commission is mandatory, which was fixed. Apart from this, the Supreme Court in Nekandi Ramalakshmi, there was issued a direction saying that a reasonable period application has to be filed. That was the case where the alienation was taken place much prior to Act came into force. The alienation was.
Is under challenge.
Yes, ma'am. For single judge. Kanti Ramalakshmi, the SLP which was referred, that was before this honorable court, my lord, in division bench, in Venkat Reddy's case, the court has held that this order was passed in a manner which was not under the law. As such, that was went to up to Supreme Court, my lord. Supreme Court has held the order passed by the division bench is correct. Thereafter, the order of the Venkat Ramalakshmi was
Can you say that proviso would be applicable only to pending cases.
Yes, madam.
Now, is it a pending case?
Yes, madam. It will be applicable to only pending cases.
No, it's pending means here or pending in the department, pending before any authority.
All pending cases, madam.
What do you mean by pending?
But cases are running. And if not initiated, the limitation will come in. Limitation will not
Pending
come
case.
is pending case.
There's a re-notification. In the stage of those, for the learner signature,
Argument is going on, madam. 13, yes, madam. 13/9 is the date was fixed for argument.
November.
City.
23, 14%, Shri Basavana Gowda. 23. 14%.
Two charge sheets are filed, madam. FIR was registered, charge sheet was filed.
who has to pass the order on his representation about police protection? The police authority will pass.
Police authority.
But what are your instructions? Do you have that? They have
Sir,
passed.
two FIRs, two charge sheets are filed against the complaints which is made by that. It's pending trial, madam. Trial is going on.
Today the challenge will be on the police protection.
He has to move before the.
No, but there is a direction now, the learner single judge, you make a representation, they will decide it.
IG, he has to make a representation to the IG, madam. That has.
Right. Do you have any information on that?
No, madam.
Just check up that.
Yes, madam.
If he has made a representation, there. None for the petitioner, we move further. None for the applicant.
2310. 24, serial number 24. Srimati Nalini Venkatesh.
IPO for the petitioner, my lord. My lord, the petitioner is challenging the order passed by the Honorable CGIT dated 2/7/19. Exactly, my lords. Here the entire 43 lakhs and odd, my lord, has been waived.
That is because of the financial condition.
Please, my lords, if some, because my lords, it's a statutory order and great loss has been caused to the public exchequer, my lords. So the CGIT, my humble submission is if the CGIT had ordered, my lords, if such an order is passed, my lords, the CGIT could have passed the order suggested by your lordship that let them approach the authority and sit and sort it out. Whatever they can afford to pay, let them pay, my lords.
Your party is there, you are also government organization, that's also government organization.
No doubt, my lords. No doubt. Now, the authority has gone strictly by the period of default and all that, my lords, and passed the order, 43 lakhs 28,000. Passed in 2014, my lords, this order.
Is this company in company, HMP?
That's what I'm given to understand, my lords.
Here there is no impediment.
No, my lords. Not as far as I have understood, my lords. I have no such instructions.
It is running, now they have a factory. What is it existence?
That's what I'm given to understand, my lords, but I don't have exact instructions. I don't have exact instructions on that point. Exactly, my lords. That's what I was about to, my lords.
Really.
2510. Serial number 25. Serial number 20.
Petitioners have been convicted by the land grabbing provisional special court for the imprisonment for 1 year, my lord.
Not find any document, exhibits, anything, how would we look into it also?
Sorry, plan.
See, we will show you, you come to your random to the ground. Para 7, paragraph.
I can send, I'll produce. Please. I can.
When will you file it?
Within a week, my lord. 15.
See, we want all the documents.
Please.
When are these 60 days expiring? On 25th July.
25th.
See, you are taking a risk.
I will produce within a week.
The counsel for the appellant is directed to petitioners. Is directed to file on record all the exhibits. All the documents which have been exhibited before the court.
Please.
And it will. In English translation.
Please.
Okay, 1 week.
1 week. Date me.
Can you file it by tomorrow? We will have it on Monday. Don't want the people will come and then pick you up and then take you.
Translation. Wednesday. By Wednesday.
By Wednesday. Oh, just give it Thursday. You want Wednesday or Thursday?
Wednesday.
By Tuesday you file it.
Please.
11/9, sir. 26 and 27 adjourn. 28, Srimati Nalini Venkatesh.
I appear for the petitioner, my lords. In this also, the petitioner is challenging the order of the CGIT Tribunal. Please, my lord.
Page number.
The order of, it's at Annexure A, page 9, my lords.
What is the challenge?
Yes, my lords. Now, the authority had levied damages of 31,57,951, which has been reduced to 30 lakhs, waiving 1 lakh and all. Only the administrative charges have been waived, saying that the authority cannot waive the. No, my lords, wrong precedent is set because, my lords, just one submission. the tribunal has relied on a decision of the Kerala High Court, wherein it was held, your lordship is aware about the administrative charges. Subsequently, in the writ appeal in the same matter, which are produced at Annexure C, my lords, that has, in the same matter, writ appeal 2182 of 2006.
Administrative charges are meant for you.
Please, my lord, please, no, but if administrative charges are waived, my lord, it would set a wrong precedent. Because it is under 32A of the scheme.
So you
32A of the scheme, I'm entitled to levy the administrative charges. That's the only point.
it would inure to the benefit of the EPF commissioner. It will come to the Provident Fund Commissioner.
Yes, of course, my lord. 32A of the scheme.
For holding the proceedings.
No, my lords.
Administrative charges are levied.
For all the, I'll just read it out, my lord. 32A. A, recovery of damages for default in payment of any contribution, my lords, of the scheme. Where an employer makes default in the payment of any contribution to the fund or in the transfer of accumulations required to be transferred by him under subsection 2 of section 15 or subsection 5 of section 17 of the Act, or in the payment of any charges payable under any other provisions of the Act or the scheme, or under any of the conditions specified under section 17 of the Act, the Central Provident Fund Commissioner or such officer as may be authorized by the central government by notification in the official gazette in this behalf may recover from the employer by way of penalty damages at the rates given below. The damages shall be calculated to the nearest rupees 50 paise and all that, my lords. So administrative charges come under this.
The damages.
Yes, my lords.
Where are the administrative charges?
Administrative charges also, my lords, I'm sorry at this point of time. Yes, just a small amount, my lords. In fact, I had advised them not to file this, but against my advice, they have filed it, my lords, because it's a small amount.
We will keep the question of law.
Please, my lord.
Serial number.
The present petition has been filed by the petitioner, Central Provident Fund Commissioner.
My lords, just one submission, because I had also filed an IA for amendment seeking to, because your lordship will be pleased to see that the cause title has to be in the name of the Central Board of Trustees, my lord. But at that point of time,
Where is your application?
IA for amendment, my lords, is filed on 10/8.
Lost. Application.
Not on record.
No, my lord, it is filed. Please, my lord. 10/8/20,
Query.
10/8/23, looks like, my lords. Because
Where is your application and will you do the amendment here only? In the past list?
I can make it right now, my lords. By virtue of circular, my lords, they have issued a circular, the head office, dated 15/9/2014, stating that the writs shall be filed in the name of the central board or state board, as the case may be, through the Regional Provident Fund Commissioner. So the only thing I have to add is Central Board of Trustees represented by. My lords,
Not its. Sir, filing seal.
Yeah. You know?
The date is serial. No seal on that.
No seal, I'm sorry. It's not happening. It may be disposed of, my lords.
So, when we are leaving the question of law.
Exactly, my lords.
they feel
It can be disposed of.
CGI. CGI. Terms of the defied the other past by the petitioner imposing damages.
Please, my lords. Under section 14B of the Act.
This T21079 instead of 315795. It's the considered the counsel for the petitioner fairly states that the amount reduced is approximately
1 lakh and odd, my lords.
Important issue as a consideration as much as whether the tribunal could have waived the
Administrative charges, that's all.
This court should decide the issue as it has in other question. Noting the said submission made by the counsel for the petitioner, we are not trying to entertain the present petition, but keep the question of law, which arises for consideration in this petition as open to be decided in some other case. The petition is dismissed.
My lord, at least disposed of, my lords. At least,
We are not entertaining.
no, I am aware of that, my lords, because that question of law is open. No, my lords. No, it will have repercussions on me, my lords. That's all. Being a panel advocate. If it can be just much obliged.
29.
Much obliged.
Happy for the petition.
So happy for the response. Lords, the common order is passed, my lords. There are 2 writ petitions, my lords. The for 19. Sorry, my lords. My lords, first issue is, my lords, in respect of APAR, my lords. APAR, my lords. Tribunal has stated that in respect of a particular year, you ignore it. We are challenging on the count that after APAR was done, my lords, it was communicated to the applicant. He filed a response representation that was considered by the committee, and order was also communicated, my lords, reject. Please. That is challenged in one petition, one way, my lords. Other one is in respect of an order which was passed under 56J, my lords, of compulsory retirement. That has been set aside by the tribunal. That is also under challenge. Not exactly that, my lords. Even that becomes a part. Apart from that, tribunal comes to conclusion that it is punitive in nature, and please, my lords.
My lords, a stay is operating against me, my lords.
It was granted after hearing both, my lords.
My lords, he has another 6 years of service, my lords. Yes, 6 years.
He was compulsory retired.
After 55, my lords, is the compulsory retirement.
Can be 6 years now.
How many years?
At the time of retirement, 7 years.
At the time of retirement, 7 years of service.
You are asking today, what is it?
Another 3 years have passed, my lord, since then.
4 years.
4 more years of service.
4 more years service.
We are still not clear. What is the retirement age?
Retirement age.
60 years.
60 is the retirement age, my lord.
60 years. What age the compulsory retirement passed? Which year?
2021, my lords.
December.
December 21.
21?
Yes, my lords.
3 years gone by?
Yes, ma'am.
That was, his age was 57 then?
No, my lords.
No.
Now it is 57 just entered.
He is just 57, my lords. 3 more years of
3 years,
service.
11 months.
Really has got.
For the parties to.
My lords, even if the APARs were considered, my lords, the APAR ratings are fit for promotion, my lords. The ratings that have been given by the department, my lords, even if they are considered, which court has said don't look into because it had been given after retirement, compulsory retirement procedure order was passed. Court said don't look into it. Even if those ratings are looked into it, my lords, it is good, very good and good which is fit for promotion. And there is nothing, no other material, my lords, except the ground that there is a decline in performance, except that there is no other, my lords, only on the upper gradings, which the gradings themselves say, my lords, it is good. 4 is good. Fit for promotion. 10, my lords.
How much you got?
My lords, 6 to 4, 4, my lords. The last of the years, 2018 and 19 is 4.
There is no contest.
No other, my lords, no contest. No, except those 2 years, my lords, which is after, my lords, compulsory retirement, first of the orders, no other, my lords. All other ratings are above that. 6 is very good. 6 is, my lords, termed as very good. My lords, have got more than 6 before that. 6, 4. Last of the years is 4. That is because, my lords, no work was assigned to me, yet my lords have been graded as very good. Short date.
Actually, what's that there during the review period?
Please,
1510.
much.
The my lords candidate is being awarded cash awards, my lords, commendation, and my lords a Kautilya award.
Please, please.
The decision to invoke 56J, or 56J was.
Please. Shorter. May I request for a shorter date, my lords? A month later. Any shorter?
Serial number 30, Shri Narayan Bhatt.
PF October.
30.
Petitioner. My lord, this is pertaining to pension, my lord, for having put in 10 years and 11 months service.
Let's,
Lord.
last occasion, this honorable court directed me to place on record how petitioner was relieved from respondent service. Yes, my lord.
IBA.
Please, 26.
ITA, yes.
My lords, I'm instructed to place in a sealed cover. I'm instructed to place the documents in a sealed cover. Please, my lords. How- My lords instructs, I will give it to him. If my lords instructs me, I will give it to him, my lord. It's his own resignation letter.
While, no, we don't say anything of that.
No, then I will take it. Thank you, sir. My lords,
That's it.
I just, I thought it will be convenient to open. My lords, the first document, my lords, is the relieving letter.
But Veller, one thing,
Please, my lord.
how did you left this organization? How do you leave? You resigned and left, na?
My lord, it was a technical resignation. The application was forwarded through proper channel.
What manner you have done it? In what manner you submitted?
My lord,
It's a question of technical resignation. We'll tell you how the technical resignation come into effect. Technical resignation come into effect. You apply for a post on deputation. Okay, you go to the borrowing authority, borrowing department. When you get absorbed, you seek technical resignation here. Because you have to sever your relationship with your previous employer. You say, I am technically resigning and I am absorbed. Now I will continue there. That's called technical resignation. But here, we find you by letter dated 30th of June 1984, and we will read it. As I have been selected for the post of Deputy Chief Vigilance Officer of the Indian Telephone Industries, Bangalore, for which I had applied to proper channel, I hereby resign the post of ACIO, which I am holding on here. That's what you say. And your resignation is accepted.
Please, my lord.
It's not that there is no precondition attached to it. Precondition is nothing there that is would be construed as a technical resignation. For what purpose it could be technical? Technical resignation is only when you go and application get a job. So you have to sever your relation. So it would be technical. Technically it is resigned because you got a job there in continuity. But here, you got a fresh appointment in ITI. When you got fresh appointment, you resigned and then that's the difference.
My lord, may I make one more request, my lord? My lord, your lordship may grant me 3 or 4 days time. My lord, I will file all the compilations, my lord, of the government orders which deal with this kind of 37 and 26. And also, my lord, there are other clarifications issued from time to time, my lord, how this kind of resignation is required to be treated.
That's our understanding. Just give it.
Your lordship may kindly grant me a few days time, my lord.
The counsel of the respondent has produced an envelope consisting of certain documents. In pursuant to the order passed by this court on the last day of the hearing. We have produced the documents. It's not that the counsel for some time to take instructions. To look into the instructions issued by the government of India. More so in support of his submission that the petitioner got relieved from the IB on technical resignation. Which will suffice to state that the perusal of the documents as produced by the IB, it is noted that the petitioner had, while letter dated 30th of June 1984, has tendered his resignation. So, just giving back. The documents which have been produced are returned back to the council at the request of counsel for the petitioner.
30th September. Serial number 31, Shrenji Patke.
For the petitioner in this matter, my question. This is regarding the damage rent. This is regarding the damage rent issue. Pass over, my lordship, at 2:30. My lordship. On 7/8, my lordship.
Ready?
Ready. Pass over, my lordship. We'll do in the afternoon. It's about seniority. Please, my lordship.
32, 32, Shri Pradeep Kumar.
So the respondent, my lords, 1 and 2.
I was seeking.
Lord, in the connected case, my lord, they are informed in the morning, my lord, they want some time.
Or 1 to 3 in the connected matter. In
200 of 2023, WA 200. Yes, my lord.
We just filed wakalat and not the councils.
For the service. The request being notified, please give a date. This we have heard.
Please, my lords, this was heard on the last date. I may request for 2nd week of September, my lord.
I'm responding number 4, I appear for the BCCI.
Which appeal?
In the first, my lord, it's
316.
316. My lord, I have nothing to do with these proceedings. I'm not a necessary party. If the office objection may be overruled regarding the written submissions and judgment, because we're not contesting in this matter. It was already submitted that.
You're not appearing.
No, we're appearing, my lord, only because we've been made a party. We're not a necessary party. Please, I'm for BCCI.
But you don't want to file anything.
My lord, it's already whatever my objections in the written petition has already been recorded in the order.
Let's say that we take on record submission of the counsel appearing for the respondent before that no written submissions are required to be filed as a service.
Please.
May I request on the second week of September?
17-9.
Oblate. September. 17. Please.
17-9.
Obliged.
Would it be on Lord 19th, my lord? Would it 19th?
No.
Name.
Lord, could it be a 19th, my lord? 19th. Eighteenth. Please, Lord, interim order kindly be extended in first case. 316 of 2023 in the first case. Obliged.
33. 33 adjourned. 34 shareholder.
Kindly pass on. Our senior Mr. A.R. Holla is held up in other.
Respondents, my lords, behalf of Shanti Bhushan DSJ, my lords. For all respondents. Senior on his legs, my lords, kindly pass over. Please.
Yes, he will come, my lords. He is held up in other court.
Passed over matters. Serial number 2, Shri Vincent.
Respondent state, my lords.
Yes.
110. Serial number 8. Serial number 8, Kumar KG.
Just say this, the human parents for the even on the second form, find that despite
Serial number 8.
despite 6 opportunities, 10 office objections have not been cleared by the counsel for the appellant till date. Accordingly, the petition is dismissed in default and opposition.
Thirty-one.
The petitioner in this matter. My lordship.
What is your name?
Pradyumna, my lordship.
Yes, tell us what are the facts. What is the order in the belly?
My lordship, we are challenging only impugned order passed by the CAT, my lordship. I was a teacher in Kendriya Vidyalaya, TGT working. I was transferred in 2018, my lordship, due to some due to allegation on me. And later, there was a ailing mother. My mother was ailing in it from cancer, and after that, I couldn't vacate the quarters, my lordship. And it was for me, it was penal rent was imposed upon me, and I approached CAT, my lordship. And CAT was granted stay for vacating quarters, my. Later, my lordship, in the year 2000, please, my lordship, there was. In 2019, I approached CAT, my lordship. In 2018, I didn't file any petition before CAT, my lordship. 2018, my lordship.
19 you went to the private.
Please stay, my lordship. Till 2024, it continued, my lordship. 24, my lordship. Please, my lordship. Right after my mother's death, my lordship, in 2022 April, she expired, my lordship. She was ailing from cancer, my lordship.
My submission to the, please.
In the stay of the tribunal, the authority of law, he was continuing to charge.
No, after that, not only for that period, subsequent period also.
No, my lord.
Vacating the quarters also. He himself submitted that I vacated the quarter, that is why only he is restricting his pay only for the damage rent. For that, my lord, the tribunal has directed to consider the authorities regarding the reduction or waiver of that damage rent. But
For which period?
beg your pardon.
From which period? 2018?
Yes,
Yes,
yes.
my lord.
Yes, till the vacation. Yes, yes. Now,
Have you passed any order?
yes, my lord.
Please, my lord.
I have passed an order, my lord, saying that we have reduced the from 500% to damage rent to 200% damage rent.
So you have reduced it. How
Yeah.
much is 200%?
Yes, 200% we are.
How much?
It will comes to 40 lakhs, my lord. 40 lakhs, my
It
lordship.
comes.
It will come to 40 lakhs, my lordship. My whole income will be gone, my lordship.
The power exercised by the tribunal.
And there is
But that much I can say.
sim,
But I can understand the difficulty of the teachers also, of course, amount of recovery of 40 lakhs, something like that.
We are not looking the matter from this perspective. He say his mother was.
Yes, yes,
But the tribunal did not accept that.
yes.
Because on the date of transfer, his mother was all right. It's only later if he got.
Yes.
The medical condition.
oh my lordship.
In any case, he could not have hold on to that property saying that, no, I will continue.
Yes.
He can't say.
Yes, yes.
But the fact remains, he went to the tribunal gave a stay order in his favor.
But no, stay was only regarding the recovery of
No,
damage rent.
Even for the
Second.
quarters also, my lordship, there was a stay, my lordship. There was a stay for vacation of quarters, my lordship.
But this is the third round of litigation. My lord. What happened was initially he challenged both the stay of vacation of the quarters. Then ultimately tribunal said, no, so far as Hindi has vacated the quarters. You regarding the damage rent, you reconsider it, we have reconsidered it. Of course, second time also it was confirmed the same rent. But subsequent third time it was remanded to the competent authority saying that you have to consider in your particular matter, since he has not drawn the HRA at Kola or new place of posting, you reconsider it, and if possible, you waive the damage rent. Now, my lord, the competent authority has said, no, we are reducing it from 5% to 500% to 200%. That is under challenge before the tribunal. But of course, but impugn order does not say what is the amount. What is you all ask back kindly see the impugn order. It does not say what is the calculation of 40 lakhs and everything.
We have produced the
He has
calculation.
calculated it, but he has calculated it.
No, it was
But the
produced.
damage rent, what they have reduced it, what is the stage method and how to pay the amount that you will also will find page number 164.
It is the state.
Please, my lordship.
State passed and for how long it continued.
Please, my lordship. I'll.
And since, of course, you will ask me not say that I have conceded, I leave it to the bench. But so far as the recovery is concerned, pending disposal of the OA court, tribunal could have granted the stay order. That is, I am not saying for the moment that the tribunal is for, but tribunal has exercised its discretionary power and said stay is not granted. So the speaking order is issued by the tribunal. But page number 137 of the OA, this is the impugn order now, my lords. Refusal to grant the stay order, the reason is. Yes, yes.
Please,
yes.
my lordship.
Yes.
Petition is pending before the OM, CAT, my lordship.
Yes, yes.
Please, my lordship.
But I have to, but I am yet to
My
file.
lordship, my humble prayer is, my lordship, until the matter disposed in CAT, my lordship, till the stay might be continued, my lordship. Please.
Last week it was posted last week.
So my lordship, it's on 5th October 4th, my lordship.
4th October.
Say the tribunal shall hear the parties and decide the way within 10 days thereafter. They will come with the judgment.
Yes, yes, yes.
But tell us one thing, pending that, what will you do? Suppose he has not paid the amount, what will you do?
But we have to recover the salary.
How would you do it? How would you do it?
But monthly installment, equal installment, we have to recover.
From where? He is retired.
No, my lordship, he still is in service, my lordship. He still has a service of 6 years, my lordship.
Okay?
Yes.
Let the tribunal decide.
Yes.
The challenge in this petition is to another dated 26/6/2024 of the Central Administrative Tribunal, Bangalore, P59 of 2024. Whereby the tribunal has rejected the prayer of interim relief sought by the petitioner in the aforesaid way. Suffice to state, the respondent sought to cover the license fee, damage license fee.
Yes.
Damage license fee from the petitioner to his pay.
Please.
To his salary. The tribunal, after noting the fact, the tribunal by a reasoned order denied the prayer. Submission of learned counsel for the petitioner is that the next date of hearing before the tribunal, in the OA before the tribunal is 4/10/24. And appropriate shall be that till such time the tribunal decides the OA, the respondents be restrained from making any recovery. His submission is also that in the eventuality the petitioner succeeds before the tribunal, then the amount which would be recovered by the respondent has to be restituted. The submission being appealing and noting the fact that the date of hearing is 4/10/2024, we dispose of the petition directing the tribunal to hear the counsel for the parties on 4/10/2024 and decide the OA within 10 days thereafter.
15 days, my lordship. There's a vacation also starts at CAT, my lordship. 1 month, my lord. 1 month. my lord.
Tribunal will be closed.
Go for,
20 days thereafter.
Please,
please,
Within 20 days thereafter.
please.
one submission. One submission, my lordship. Before granting interim stay, this Honorable High Court had ordered me to deposit 75,000 rupees before the competent authority, my lordship. And I have deposited 75,000 rupees before the competent authority.
Now tell us,
Please, my lordship, the interim order was granted.
we take on record the submission made by the learned counsel for the petition. That pursuant to the order dated 23/7/2024, the petitioner has deposited an amount of 75,000 with the competent. Just say here.
Right. 34,
Yes.
Greatly obliged, my lord.
34.
Please, the order has to be set aside. Please.
So we have raised the issue that has not been decided by the tribunal.
Lord.
So we'll do one thing, only on this issue. Mr. Ola, insofar as the other issue is concerned, what was the other issue which raised?
He was not willfully absent, my lord. That allegation is not there.
That has attained finality. Even that the tribunal now decide this issue.
Lord, insofar, looking into the order passed by the tribunal, Lord, it's as though the tribunal is sitting on an appeal on the medical evidence. Therefore, my lord, my first submission was that, my lord, the entire order has to go, my lord.
Well, we'll set aside the entire order and we will ask them to decide the de novo.
Please.
Where and we'll leave all the contentions.
Very well, ma'am.
Let be the order of the court, ma'am. Please. The reason is this, my lord, the other central government council was to appear, my lord. From past 2 times he is not appearing. Therefore, my lord, great.
The time limit may be fixed, my lord, for disposal of the case.
It appears to be a finding of willful absence against you.
My lord, there is not an allegation of willful absence, my lord. Let alone the evidence. Let the tribunal decide, my lord.
The dated. Twenty-ninth August. 29th August 2018, the original application 00286 of 2017. So where the tribunal has dismissed the OA filed by the petitioner herein by stating in paragraph 2 of the order as in that. So the submission of Mr. Hoda is twofold. According to him, according to him, though the petitioner was it by way of a charge sheet?
Charge sheet, my lord.
Yes, sir. Sir.
According to Mr. Hoda.
Annexure A6.
Yes, sir. Yes. Please.
Yes, yes, ma'am.
The impute action was taken by the pursuant to a charge sheet issued to him for absence. So the justification given by the petitioner is about his being unwell. He's being unwell.
His mother is not well, my lord. He has to look after her, his mother.
Being unwell.
My lord, your lordship would be.
Attending to his mother. And as such, the absence cannot be treated as willful. Willful. And in fact, it is his submission. There was no charge framed in the charge sheet that the petitioner was willfully absent. The second submission is that the petitioner, being an employee of the government of India, go on deputation, on deemed deputation with the Prasar Bharati Broadcasting Corporation of India, the chief executive officer could not have the authority, the president would be the authority.
No, secretary government, my lord.
The Ministry of Information, the authority under the government of India, as different from a chief executive officer of Prasar Bharati Broadcasting Corporation of India, that bracket autonomous body, should have passed the order of penalty, being the appointing authority. So Mr. Hoda submits that despite an aberrament in the OA,
yes, ma'am.
Where is that? Which paragraph?
But I will take the.
Para 2, page 13. Para 2, page 13 of the petition, my lord, order. In page 2 of the order.
Despite an aberrament in that regard, the tribunal has not considered this said aspect. In other words, it is submission.
First ground, my lord, 23 page.
In this submission, if the plea of the petitioner is accepted, then the very initiation of who should charge it?
Charge sheet issued by the
Page 41.
Director General Doordarshan.
So the penalty order has to becomes illegal. It's only the penalty order.
Yes, ma'am.
Becomes illegal. So though Mr. Shanti Bhushan, Deputy Solicitor General for India, would support the order passed by the tribunal, consider view by this court. We are of the view that the issue raised by Mr. Hoda, the issues raised by Mr. Hoda in support of the stand on behalf of the petitioner are appealing. But in fact, we find the second submission, insofar as penalty having been passed by not a competent authority, has not been dealt with by the tribunal. In fact, we find that Mr. Hoda has relied upon, which is the document that gazette notification.
Annexure D.
Annexure D, my lord.
Annexure D.
D.
Madam.
Annexure D of the pages 110, 115, wherein it states, inter alia states, provided that the power to impose major penalties of compulsory retirement, removal and dismissal from service shall be exercised by the central government, has not been dealt with, has not been considered and dealt with in the impute. Accordingly, we set aside the impugned order dated so and so and remand the matter back to the tribunal by reviving the OA so and so to its original number. Now, with the direction to the tribunal to consider the OA afresh and would rehear the parties and consider decide the OA afresh. The OA afresh is all the contentions of the parties are left open to be canvassed before the tribunal.
Much.
The reason for the central government, my lord, this notification is, my lord, you'll get it at page 1, that all officers and employees recruited for the purpose of Akashvani before appointed date of and in service, the corporation from the first day of 2000 shall be deemed to be deputy. That is the reason, my lord,
And that proviso clause possibly supports his case.
that's true, my lord. Please, great.
My lord, time limit. may
Sorry,
be
my lord, I
extended.
was on my legs, my lord, I apologize.
Because it's more than 10 years now.
Is granted to the counsel for the commissioner to make a request for the tribunal for early disposal of the student. We don't want to, say anything, just
Yes.
make a request, which shall be considered by the tribunal in accordance with the board. If the board permits, shall we say so?
No, my lord, there's hardly few cases are there.
You make a request.
Yes,
Great.
ma'am.
Great.